Today I'm meeting with Jason from Bringhurst Process Service, and we're going to talk about service of process and how that's the first step toward getting a lawsuit started. Once you've filed with the court, you've got to give notice to the people you're suing. And if you're not aware of this already, when you file for a divorce, it is a suit for divorce. You are suing for divorce. So we don't want you to be unhappy or upset about that, because that's simply what a lawsuit is about. So Jason, first of all, thanks for being here.
Absolutely, thanks for having me.
And we want people to understand a little bit about how that works, because there's a lot of mythology that has grown up around what getting served with process means. So why don't you tell us a little bit about what it means, and then tell us about how you go about doing it, or the different ways it can be done.
Normally, after a suit has been filed in the court, we get it from our attorney, our client. We go and to the addresses that are given by our client to find the subject.
Well, let me interrupt right there. So you're saying the client is who? Your client is whom?
Most of our clients are either attorneys or debt collection agencies.
So in other words, you're being given a copy of the complaint that's been filed.
Yes.
To give to the person who's being sued, who probably doesn't know it yet. They might be suspecting something, but they don't know it's been served until they get a copy of it, and you're the way that happens.
Yes.
So what do you give the person who's being sued?
So, for instance, with a divorce, it begins with
Yeah.
a summons. So it would be a summons and complaint for divorce.
And what does the summons say?
That's just basically telling you that you have a certain amount of days to answer and file a written answer with the court or with the client.
Okay. So they get a summons and they get a copy of the complaint.
Yes.
All right, and so you were going on to say, so your job is to get that into the hands of the person being sued. So
Yes.
how do you do that?
Normally, we have an address, just our home address, and go knock on the door and give it to them personally, or anybody that lives there with them can accept it as well.
Well, now, that's interesting. So you're saying that if I'm trying to sue John Doe, you don't have to go and find John Doe necessarily
No, sir.
to have him served. So who can be served besides John Doe himself?
Anybody over the age of 14, in the statute it's written as anybody of age of discretion, which is normally looked at as the age of 14 years old, and a resident of that house.
Okay. So if you go to knock on the door to serve John Doe, and John Doe's daughter, who's 14, 15, 16, answers the door, tell me how that would work. So just give us an example.
If I'm there to serve you, I'd
So
say,
I just open the door like, hello?
hey, how's it going? Is John available?
No, he's not here right now.
Okay, do you live here with him?
Uh-huh.
Okay, and how old are you?
Well, I'm not supposed to talk to strangers.
Are you at least 14 years old?
Yeah.
Okay, do you mind giving this to him when he gets back? I'm just going
Sure.
to fill it out. It's
Yeah,
some
I'll
court
hand it to
documents.
him.
Just make sure he gets it when he gets back.
Okay.
Thank you.
Yeah, see?
That's a pretty simple idea.
So a lot of people don't know that, is they think, oh, like if I can't be found, then I can't get served. But that's not true.
Common misconception.
Okay. What are some other things about service of process that you hear that people are afraid of that they just don't need to worry about?
I think a lot of it comes from just trying to avoid any kind of issue. People are always afraid of being in trouble, and most of the time you're not in trouble. You just need to file an answer and deal with the situation at hand.
Do you think some of that comes from people seeing someone at the door with a badge or something like that?
Possibly. We don't actually carry badges. We're just process servers and private investigators.
So you could actually dress just like you are now, go out
Absolutely.
and serve some process today.
I've been serving papers today just like this.
Okay, all right. Now, we were talking a little bit beforehand, before we went on camera, about the guy who shows up at the door with a pizza box and all that sort of thing. Does it ever get that exotic for you?
Not for me, no. And part of the reason for that is I actually discourage things like that. And part of the reason for that would be we're going to serve people more than once, most of the time. So the summons would just be the first step. And then you're going to go back to the door with maybe that second step and third step, depending on how far that lawsuit or the situation is going to go. And if you try to trick them the first time, they're not going to have enough respect for you to answer the door the second time.
So let's assume that I'm actually somebody who wants to act in bad faith, and I know that I'm going to get sued.
Okay?
And we're just talking about the civil side of things. I mean, there's things that you'll serve like warrants and other things like that, but we're just talking about the divorce situation. So I think, well, if I can't get served, then the case can't go forward. Is that true?
Absolutely not.
Okay, so let's talk a little bit about you're trying to find me, and I know you're trying to find me. So I will park my car across the street, and I'll hop some fences and stuff like that. So you can never tell I'm there. Tell me what happens if first of all, how many times would you try to serve me at home?
Yeah, give or take 5 or 6 times. And if we can tell that you're hiding, let's say we see movement inside the house, we make note of that. And eventually what we'll do is we'll take that information back to our client, and they can take that information in front of the judge and get what's called a due diligence.
Okay.
And when the judge sees that, they make their decision on whether they can do what's called an alternate service.
Okay. So you'll try to find me 5 or 6 times maybe, and then if that doesn't work, what are the other ways that someone can get served if they're not personally served or somebody who lives in their home with them of suitable age is not served? What are some of the other options people would have?
Legal publication
Okay.
would be the most common.
Okay, so that would mean publishing in a newspaper of general circulation in the city or county where that person lives. And now, because people are reading newspapers less and less, you can do other things such as with the judge's permission. It's not something you can choose to do on your own, but you can post it on Facebook, you can email it to somebody, sometimes you can serve somebody by text message, but that's something that you don't get to choose to do. Is
No.
that right? That's something that who has to approve?
The judge has to approve it, and that's normally taken care of by our client, not by
Right,
us.
not by the, so you're the people that deal with people face to face,
Yes.
person to person, things like that. Okay. Well, how much does it cost? I mean, is that part of the filing fee that I pay in court, or do I have an additional expense?
It is an additional expense.
All right. If I am representing myself and don't have a lawyer who's doing all the work for me, what would you charge a pro se litigant?
Okay, so pro se, anywhere in the Salt Lake County through Bringhurst process would be $45, and it's a one-time fee, and it's paid up front.
Are you limited to serving only in Salt Lake County?
No, I'm not. We serve papers statewide.
Okay. How do you, let's assume that I ask you to serve something in St. George. So there's my $45, and I'm a pro se litigant, I don't have a lawyer. I pay $45, and then how do you charge for the travel, or do you charge for travel?
St. George in particular, I actually have somebody that lives down there that takes care
Okay.
of all the St. George, Iron County, and the surrounding areas down there.
So it's still $45. But let's assume you had to drive up to Farmington from here.
Okay, yeah, we have people that live up there as well. And if it's something that needs to be done on a rush basis,
Okay.
it's a little bit extra fee for that. It's typically a $30 fee for a rush fee, and we'll have somebody take
Over
off
and above
get-
the $45?
Yes.
Okay. So it's not terribly expensive, but also not free. It's not something that's
No.
included. You've got to have that as an additional expense, and people should know about that too. Anything else you think people ought to be aware of about service of process, or things that any myths, any urban legends that you've heard about that you want to dispel?
I think the most common one is you do not have to handle the paperwork in order to be served. You don't have to sign anything. I get that a lot. I'm not signing anything, and that's a common misconception.
So if somebody's at the door and you say, "Are you John Doe?" and the guy says yes, and you're like, "Okay, well, you're trying to hand it to him," and he says, "Oh, I didn't touch them," and then slams the door or runs away. Is that person not served? I mean, after all, he didn't take them from your hands.
Nope, he would be personally served at that time.
So what do you have to do? What's the minimum thing you have to establish to have service of process on the guy?
So when we make contact, like you said, if he admits to being the defendant that we're trying to serve, at that point in time, it's pretty much over. You've
Okay.
been served. If you're trying to avoid it and you say, I don't know who that is, and then slam the door, there's no way to prove it. If we have photo ID, something like that, we can still leave it and say we verified ID, something like that. But
Okay, so I came to the door, I saw you had papers, and I thought that as long as I don't touch them, you can't serve me, but you can just drop them on the porch, even if I slam the door, right?
Yes.
What if I don't answer the door, and I just peek through the curtains, and I say, "Go away"? Have I now thwarted your efforts to get me served?
absolutely not.
Okay.
If we can still verify it's you, yeah, that's me, but I'm not answering the door, that kind of thing, again, you've admitted it's you, I've seen you, it's done.
Okay.
And
So
I'll leave it under the doormat or something where it's secure, it's not going to blow away.
you might be able to put off getting served and slow your case down a little bit, but if the process server knows that he's being shined on, you let the client know. Client can go to the court saying, despite our best efforts, our due diligence, this person's avoiding service. Then you can get them served by the newspaper or some other means. And if they get served that way, they may never know it's happened.
They may not, and then it's going to go, let's say that it's for a judgment, it's a small claims judgment. Well, it's going to go in front of the judge. They're going to say you were served by legal publication. The judgment's going to be awarded.
Oh, but I never saw
and
it.
I have a judgment against
but
you.
I
and
never
you didn't
saw
know
it.
Sorry,
Yeah.
you avoided service.
Right. If the judge considers that you've avoided service, all you have to do is then print it in a newspaper or a Facebook or an email or something like that. And if you didn't see it or claim that you didn't see it, it doesn't matter. You've been considered served whether you took it or not.
Absolutely.
Excellent. Well, thank you very much. There's not a whole lot that we need to talk about, but it's very important to know about service of process and what it accomplishes and how you can or cannot avoid service and what the consequences are. So thanks for dropping
Well, thanks
by.
for having me. I appreciate it.
All right. One more question, however, before we go, because I forgot to ask this and I need to make sure that I do. Why should I even bother going through the expense of having you or some other process server do it when I know where my spouse lives, or I know where the person I'm suing lives or works? I can just go over there and give it to him myself. I'm over the age of 18.
Absolutely. You're going to run into a problem if your spouse or soon-to-be ex-spouse is not going to be amicable with the divorce. You're going to need to have those papers served.
Why can't I do it? I mean, I know where she is. Why can't I just hand her this?
Because she'll deny it. Plain and simple, if she denies it, there's no proof. It's your word against hers, and obviously if you're getting a divorce, who's going to believe who?
I'm interested in claiming it happened. So you're saying
Exactly.
There's a very good chance that people might think that I claimed to have served her and then let the 20 days go by and then defaulted her. So if somebody, you don't have a dog in the fight, you're a neutral party, so you're believable, you have credibility,
Yes.
because you're not someone who's hoping to win like I might be. And that was a very good point. So if you think, well, I'll just save the money and not have someone paid for the service of process, you can't avoid that. Now, I will mention one other thing. You can certified mail it, and that's not something that you have to do. That's someone that, if I'm the pro se litigant, I can put it in there, and then I mail it to the person I'm suing, who then has to sign the card before it's given, and then the proof of service is in the signing for the card.
Yes.
Good. So anyway, now we're finished. Now I'll shake your head.
All right,
and again,
thank you.
thanks for coming by.
Absolutely.